The difference between statement and step five. Okay, sorry. Appearance is for the respondent. Okay, sorry. I'm only where are we?
So sorry, the matter is stated for trial. The appellant has concluded its case. So it's for the respondent.
There we go. Yes. 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 That's the true position. Are we ready to go on? Yes, we are ready. Our witness is standing visually on. Do you understand? Our witness is present online. She's already present online. She's at a visual. Because since there was no previous reference to that, I beg you prayer. Yes, I honor question on the members of this tribunal. I'm very sorry for the impromptu arrangement I just came up yesterday. Just like I hinted the tribunal during the last thing about some structuring and for the organization that's going on with Nigerian Revenue Service. We actually made several efforts to make sure that the witness is physically present in court. But just yesterday, we got new information concerning her health status and her inability to make it today. So in order not to disappoint the tribunal, and considering the earlier information the 100% now passed on me during the last sitting, I formally requested to the Secretary of the Tribunal in this visual meeting and set up another month to store today's news. And graciously, we were invited and the television meeting was set up and the link sent us to another of us to join the proceedings that are pointing on this note, I really apply the tribunal recognize and monitors on this circumstance on it. Mainly with Mario.
Mr. Chairman, honorable members, we were informed by respondent justice of the circumstances that our witness will be joining online due to circumstances beyond our control. We have no objections.
Please. Facility able to accommodate the children here.
The application for virtual hearing is hereby granted. The tribunal having been satisfied that the requisite facility, which was previously unavailable, is now fully functional. Granted, this will serve the interest of justice and fair. Yeah.
As the tribunal, yeah, okay. They are only applied at the ministry. Stand for it.
Witness. If you are witness, not the party, and you intend to testify in this matter, still of the tribunal and out of hearing. Witness. Witness, don't respond. Unmute your camera, unmute yourself. Unmute yourself.
Yes, please, I can hear you. Good morning.
Do you have the Bible with you there? Do you have the Bible with you?
Hello?
Do you have the Bible with you?
Yes.
You want to swear or you want to affirm?
To affirm.
Okay. Repeat after me.
Yeah.
I,
I,
your name,
Ozo Doris,
solemnly and sincerely declare
certainly as declared
and affirm that evidence I shall give,
and affirm that
the evidence I shall give
the evidence I shall give
will be the truth,
will be the truth,
the whole truth,
the whole truth,
and nothing but the truth.
and nothing but the truth.
Witness, you please be reminded that you have been sworn, and so you are to testify in this matter.
Yeah, Mrs. Doris, can you hear me?
Yes, I can hear you perfectly well now. Yeah.
All right. You are under oath before the Honorable Tribunal. Please, can you tell this Honorable Tribunal your name once again?
I am Ozo Doris.
What's your rank and the office you represent?
I'm a senior manager tax as FIRS Large Tax Office, Okra, Anambra State.
Okay. Can you remember making a witness deposition before this Honorable Tribunal on 30th October 2025?
Yes, please.
If you see the document, can you identify it?
Yes.
Please, can you look at your screen? Check.
Okay.
Okay, take a look at your screen.
Yeah, I've seen it.
Is it your
I can
witness?
remember.
before this honorable tribunal?
Hello?
Is the document before you your witness deposition before this honorable tribunal?
Okay.
And you football. Can you confirm the document?
Yes, I can see it.
Correct. Mr. Chairman and members of the honorable tribunal, we apply to say that Mrs. Doris also witness statement on oath as her evidence. Good.
No objection, sir.
The witness statement for this.
As a criminal witness. Mrs. Doris, can you still hear me? Witness, can you confirm if you can hear me? Witness, can you hear me? Witness, can you unmute yourself? Can you hear me?
Yes, I can hear you.
Okay. I want to refer you to paragraph 40. Paragraph 40 of your witness statement.
Yes, I can see it.
Okay, you have seen the list of documents you intend to rely on this matter.
Yes, please. I've sent it. A to M.
Okay, I want to take you particularly on paragraph 40 sub K. FIRS VAT reassessment notice dated 10 July 2025.
Yes.
Yes, if you see this document, can you recognize it?
Yes, of course, I can.
It's my humble apply that FIRS VAT reassessment notice be projected to the witness. Okay, can you see the document?
Yes, I've seen the assessment, and I recognize it as part of what I issued to the taxpayer as their
Alright.
tax liability additional assessment.
Okay. So what do you intend to do with this document? Do you intend to tender it as an evidence in this case?
Yes, please. I do.
Mr. Chairman and members of the workshop, now we applied to tender this VAT reassessment notice dated third, dated 3rd of July 2025 as an executive.
Okay, to make it this year, are you tendering all the documents we have here?
No, Mr. Chairman, the document listed here is virtually the same document they have been displaying, and they have all tendered it. So what we intend to do is just to tender the one they did not tender, although we are relying on the same documents. But it's been tendered. If we tender it now, it will just be a duplication of that documents. Certainly,
Circumstance, how many documents that you tendering?
only one, just this document.
That's all you're doing.
Yes.
Say this, I'm not having a picture.
Document referred to in paragraph 4, subparagraph K of the witness deposition is hereby admitted as exhibit and marked exhibit N.
And the tribunal basis. Yes, Mr. Chairman, that'd be all for the.
Do you have it was so swift that I don't think you have any.
Yeah, just.
Please, it's your time for us.
Yes, I just need a few questions. To be very brief as a lady's case.
So again,
It will be very brief, sir.
as like what?
Yeah, like they say, like as brief as a lady's case, like they say.
Okay, I'm not very conversant with the knowledge you have.
Just a few minutes, sir.
You're welcome.
Yes, sir. Witness, good morning. Can you confirm you can hear me?
Yes, I can hear you.
Please, can you stated in your witness statement to know that you're a senior manager in the Federal Land Revenue Service.
Sorry?
In
Hello?
your witness-
Yes, I'm a senior manager.
Can you tell this honorable tribunal your qualifications?
Can we agree together, all of us, that FIRS is NRS? So we'll be dealing with this.
Yes, Lord, in any case, the law has already recognized the name of the company or any statutory of the religion, even if the name have changed, does not mean that they have discarded the alien name. So the two names can actually be used interchangeably. But I totally agree with Mr. Sherman that we should maintain Nigerian.
Okay, because at the moment, the FR is not recognized form, so they beware. So that we don't challenge whether what where she was at the time of giving this decision was valid. So if it's NRS, let's call it as NRS.
Take the heat, sir. So witness, you stated that you are a senior manager in the office of the respondent, the Nigerian Revenue Service. Correct?
You're right, sir.
Can you tell the Honorable Tribunal of qualifications?
Academic qualifications.
Yes.
All right. A master's degree, MSc, banking and finance option, MBA business administration, BAc finance, banking and finance. Then associate member of Chartered Institute of Taxation of Nigeria, associate member of Debt Management Office of Nigeria, member Chartered Institute of Cost and Management Accounting.
You have not worked in a manufacturing company before. Correct?
Sorry?
You have not worked
Worked, as in worked.
as
No.
an employee, cannot be employed or worked as an employee in a manufacturing company before. Is that correct?
Yes, you're right.
So you are not an expert in the matter of glass manufacturing in general, glass manufacturing, correct?
I know their production line and how they operate because we've been dealing with a lot of manufacturing company as a taxpayers, and we do visit them to see and assess them on the kind of work they do. So I think I have 30 years of experience with manufacturing companies in Nigeria of different product lines, not essentially glass production.
So the first sentence she get that she knows, I need to get that again. She said she gave a specific knowledge.
Okay, witness, can you state your answer, the response?
Especially what you said first.
Sorry? Can you be a bit audible? I can't hear.
Your response. Can you repeat your response, please?
Especially the first sentence you made.
The tribunal is trying to record you, so speak slowly so that they can pick exactly what you're saying.
Okay.
You can go ahead and the answer.
Okay.
Is,
I should repeat what
yes,
I just said. Okay, I should be speaking slowly.
Yes, so that they can record you properly.
Okay. Okay, I've not worked in a manufacturing company. Can you hear me?
Yes. Go ahead.
I have like 30 years experience dealing with taxpayer in such sectors, and we visit them with different product line and different products they deal on, and we see what they do. And I believe with such experience, you can actually tell what a glass manufacturing company do and other products. So, and I think it's enough to know what they are doing, both visitation and what have you.
But you are not an expert.
I'm an expert. I'm a member Chartered Institute of Taxation of Nigeria.
Sorry, Mr. Chairman, if I might be pleased. My objection is that word expert.
I'm a tax expert. That's my field.
Yes, Mr.
That's a question for the week.
It's a question for the witness. She has answered that.
If you
She
think
has answered his question very correct.
if you think there's ambiguity of such, you don't want to do it.
The word expert has no any
And
straightforward.
we at this point define the word experts. It's not a question, it's a question to a witness.
As a general application.
If there's what you're trying to raise is issue of ambiguity, is it not?
No, he's just trying to put words inside the witness mouth. She has answered that his question.
Council. The council on the other side asked the question, which the witness has answered. What is your argument?
He repeated the same question in a minute trouble. You are not an expert. He asked me this question before. Are you an expert in social field? And she has given her response to him. Then he now repeated again, are you an expert? Like the word expert, it has different meanings from different purposes.
That's what I think I would rule. Respectfully, we overrule that objection.
As a general application.
If there's ambiguity at the right time, sure you know what.
As a general.
Thank you.
Thank you, sir. So the witness was trying to answer the.
Look, we're asking.
Yes. So my question is, for you are not an expert in glass manufacturing. Yes or no?
I'm a tax expert. I'm a tax expert in manufacturing company.
Next question, please.
In witness, in paragraph 33 of the witness statement, you mentioned that based on the respondent's review of the appellant's returns and records, that 55% of the gas and spare consumables were used in producing VAT-able outputs. Is that correct?
The taxpayer brought a lot of invoices which are not relevant to the month of review, which are not, some of them have not been duly utilized for the period under review, which should still be under unused VAT, not wholly used for that particular period. So, and most of the invoices brought are not within the tax net. That means they cannot be used. They don't have a taxpayer's identification number. Because of that, the taxpayer brought more than the inputs VAT claim for the 2 periods. So that was why we used 55% of the gas, the one he brought as gas for production. Okay. Enough.
It's good.
So that means the appellant provided a breakdown. The appellant provided invoices to show input facts that it was claiming. Yes or no?
It's the best of it.
The appellant provided invoices, documents as proof of the input VAT it was claiming.
Initially, the
True or false?
false. Initially, he didn't provide till we requested. That was when he provided. False. He didn't provide initially. Yeah. It was on our request. You know, he didn't provide, which is a contravention of VAT Act as amended to date. We requested and he provided.
The appellant also provided a breakdown of how it utilized the units of gas and consumables. Yes or no?
The half balance provided what is not allowable as an input in a glass manufacturing company, which is shrink nylons, pallets, and carton tray, even cables. It provides cable as an input for a glass manufacturing company, which is purely for storage and transportation and not an input. It's allowable in line with section 17, subsection 1 of VAT Act as amended to date. So subsequently, we have to use section 18 of VAT Act as amended to date, and we raise a BOJ assessment of 82 million for him to make payment on.
Question is, so I'm trying to get your response. So your response, the appellant did not provide a breakdown.
No, we just brought scattered the invoices for different periods or which are not under review.
The appellant brought it first.
The civil books are we trying to say that details are not specific, or where details provided but not specific? What's exactly is the position?
So
I mean, then when you can have to communicate, about 3 synonyms were used. And to be specific, I would say that yes, details were provided, not adequate, or what exactly is the position.
This is Doris, can you hear me?
I can hear you.
So, Marigo,
are
you okay with it?
very well, sir.
Okay, if you can listen to the tribunal, they want specifically your response to this last question. They want you to be very direct based on the question whether the invoices, the breakdown is talking about, whether it is in relation to the period in question and in relation to areas they needed to provide invoice to prove their case or not. Please just be very specific on the nature of documents the appellant submitted to the office.
Okay, what I just want is specificity as to details. So, Marigo, can you ask this to
So
thank you.
yes, sir. If I should phrase the breakdown, the appellant provided a breakdown of the gas and consumables, gas that was utilized in production. The appellant provided a breakdown of that expense. Yes or no? Separate from
The
the
app- The appellant brought a breakup of gas that is more than the total input VAT for the period, which cannot be relied on because, and the period under review, most of the ones he got, the period under review, they are not part of the period under review. So those documents are relevant. That was why we use our own best of judgment, since they are not in line with section 81. They are not in line with section 17, subsection 1, as that as amended to date.
Thank you very much. Do you have an apostle?
Yes, yes. So it said, so yes, the appellant provided. So that's what you said. Say yes, but the record of the tribunal. Look,
Is that a question?
it's not a question, but okay. The witness just keep going on, and it makes it easier for all of us. If you just answer, so we can move.
Pastor, do you have an apostle?
Yes, sir, I do. I do. So when you form the view that the documents provided by the appellant was insufficient, you did not inform the appellant or make any further requests. Yes or no?
We did. We communicated the taxpayer. We communicated them. And severally on so many occasions, So we actually communicated them.
Do you have any evidence before this tribunal to prove that subsequent communications?
Yes, in my first letter, where they are supposed to attach inputs, documentary evidence of input claim, my first letter exhibits, I think that's the first exhibit. They have already broken the first law of VAT Act as amended to date by not attaching those invoices. And when requested, they brought irrelevant documents which are not an allowable input, like cables, shrink nylon, pallets, and carton tray. Those documents are irrelevant to their product line, and they are not for direct production of bottles. So, and they were disallowed in line with the provision of the law.
So you made reference to the documents. The documents, that document is before the Olympic tribunal.
That's clear.
My lord,
That's clear.
my lord, please, if I might be permitted, sir, I am here to bear your witness. And these documents are the form I wrote. These are exhibits before this court. Can another evidence actually contradict a written document? If you want to consider the details, she was not there in the hearing for her to be able to tell exactly the LSDP. But I reference you that you have communicated to the appellant several of different occasions. To be enough to get her answer.
You are addressing this.
Yes, but my question is asking her specifically to start reading a particular paragraph of the LSP now. To me, it is an excellent one because even when she is now, I cannot be able to show her this document for her to be able to say, yes, this is an actual document I'm talking about. And all the correspondences between the parties are before this court.
As we agree that we have a role to guide you. Yes. But you also remember that the witness is not that old. And the tribunal questions are to be answered by the witness who is on that oath. Where there are issues, like I keep saying, you know what? I don't see the problem, and I don't see the beat, and I don't think it's been raised that she should repeat what has happened before this film. If I understand very clearly, and correct me, counsel, if that is not the question, whether the document you made reference to is before this court. We will allow her to say either she's not aware, she can't remember, whatever answers gives is not the end, but we must hear from
As a tribunal can decide.
counsel. Can you repeat the question? Very clear question, don't make it.
Yes, sir.
When you overflow the question, the will come out processed.
Yes,
So I
sir.
expect to process it the way intelligent person I've seen and answer it.
I take it with sir. So witness, my question is on documentation for VAT, input VAT on gas. Do you have any document before this tribunal where you requested for further clarification from the applicant on these subjects? So,
Yes, I do. Is it those letters that with the lawyer?
please, I'll need you to identify that particular part. It's the letter is your letter, so please point that aspect of it.
I go to my first letter. The first one I wrote to them on because they did not attach documentary evidence of allowable inputs. You cannot claim an input without an evidence. So, and it's from there that they were asked to provide the documentary evidence. Check out the second line of that box there in my letter.
What they
That your objection with documentary evidence in support of your claim is expected within 2 weeks. Within 2 weeks, almost to the last paragraph, failing which the notice of assessment shall be injected to the tax payments. So when you watch that phrase, you see that's me requesting for the documentary evidence. You cannot claim an input when you don't have none, or manufacture an input when you don't have none, and or give an input that is more than the period under review. It's wrong.
It's sort of, she's referring to exhibit A1. A1. It's dated 6th of March 2025.
Yes, almost to the last down. You see, I say your objection with documentary evidence in support of your claim is expected. I gave him up to 2 weeks to of the date of the letter, this being 6th of March, to bring this evidence, which he did and brought those ones that are irrelevant for the period under review.
At this point, considering that it's a virtual hearing, if she was to be paused, I know that the passport can also apply and show it to her. So at this point, if there's any intervention plan, therefore, we specifically to identify what has been written in this court to refresh her mind, we are free to do that.
the tribunal is
Yes, but look, the witness have already, like I said, the witness, the document the witness made a reference to is the letter dated 6th March.
That is exhibit
Exhibit A1. Yes, my lord. And the paragraph she's trying to reach, the last paragraph before her signature. Where she said that if I might be permitted to read it. Go ahead. Your payment or objection with documentary evidence in support of your claims is expected within 2 weeks from the date of receipt of this letter, or this letter of intent, failing which the notice of assessment shall be injected into the tax promise for immediate payment.
Thank you.
Payment. Yeah, you're right.
Very good. We have noted you and our reference to the you have further questions.
Yes, I do, sir. I do, very well, sir. Exhibit A1 reference does not speak to gas consumables. We can take a look at it again. There are items that were mentioned there. My question, sir, wasn't gas consumable. My question was specific because the appellant claimed a number of things, sir. And the respondent, the appellant has a number of claims. If you look at it, you see sales, you see impunity on sales, and then specifically the appellant claimed impunity on gas separately.
No, you know you have the time to address us and appropriate time, but for now, what are the specific questions you have for association?
Officer.
At the right time, no questions.
Noted at the tribunal please. Noted. In your letter of 5th May 2025, which is what I expected her to bring before the tribunal, not this, which is when gas was mentioned, 5th May 2025.
Is that the question for us?
No, it's for her. Your letter of 5th May 2025, witness. In your letter of witness, confirm you can hear me. Witness, please, can you confirm if you can?
I'm listening. What did you just say? That you are talking of gas. It will not be mentioned because the taxpayer never for once filed any invoice in respect of gas during that period. That was when I requested for documentary evidence of impute he claimed. So why will I request for gas when he never even dropped one single invoice? So that was why I said, bring documentary evidence to support your claim. And none. It was subsequently that he started attaching a lot of irrelevant documents for the period under review. So why will I mention gas in this one while he never submitted it? It's the ones he submitted that I will mention, you know?
In your letter,
He just...
Thank you. We've heard that. Thank you. Your reference to the letter of May 5th.
Yeah.
Are you satisfied?
no,
Hold on. Are you still asking questions on that?
yes, I'm thinking.
Okay. In that case, also, because she's not present here, I will ask the council to refresh her as to that's exhibit what?
This is exhibit D.
Exhibit D.
Later the 5th May 2025.
Okay, witness. Witness. The next question the council is going to ask you is going to border on exhibit D, which your council will intimate you about, because we are not here to identify it clearly. But if you're in a position to, you just explain it to the extent that you can understand the data being talked about, not essentially the details. So therefore, let's remember the data by date and heading.
Yes,
So she can speak to it.
yes,
She's the author of the letter.
yes.
Okay, just remind her of the data so she can speak to it. Yeah.
This letter is dated 5th May 2025. It was actually a response to the earlier letter written by the appellant.
Okay, so witness, do you understand the letter now?
No, which date?
5th May
Six-
2025. Remember that this letter is actually part of the document online. The letter can actually be projected to her.
Very clear, you can.
It's not that this letter dated 5th May projected to the witness. Yes, yes.
Okay. Okay.
Also, the religion.
Yeah, so in paragraph number 4, paragraph 4 of that.
Okay.
Where you say the allowable, only allowable bids of invoices are consumable spares and the gas of 128 million 48. That's my point. That's amount on gas, not the other one. This amount for gas. This, did you request for any documents after in your letter? Is there any evidence here that you're requesting for documents or further clarification from appellant on this? That's just my question.
And that's the only document he had, and that was what they provided. In respect of the gas of 128 million 628 409.77. They just submitted this and it was recognized.
They submitted
After,
this is your letter.
yeah.
Witness, counsel.
This is your letter. So why are you saying this?
The witness, hold on, is the question whether they requested for additional data other than this detail. Is that your question?
Yeah, what are you requesting for additional documents? Yes, sir.
Other than that detail shown in paragraph 4.
Yes, sir.
Witness,
Yes, please.
my understanding of the question is looking at exhibit D, which is before you, particularly paragraph I-4.
Yeah.
Whether you requested for additional details other than what is presented in exhibit 4. Is that your question?
Yes, sir. That's the question.
No, the ones we requested, they didn't tender. They tender the irrelevant ones, and we pick the ones that is relevant for the period under review, which gas is part of them, because it's like it brought the whole gas for the period for the year, and we have to do a 55% being a proportionate of provision based on 45% will be stored for other months which has not been utilized for the period.
Okay, we clearly understand you and we appreciate your ability to give details. However, as a tribunal, we need to be particular about the response because when the question has been answered, we are particular about the response in a way that we can interpret it. So again, I want to be as brief as possible. Apart from what we showed in exhibit D4, are there other things you requested that we are not given to you? Is that still the question?
Very well, sir.
Are there other documents you requested specifically, but we are not given? In your previous answer, you've told us that they gave you a lot of things that were not relevant. We have noted that far, but in our record. But are there other things you requested that were not given?
The only thing I requested from the company is documentary evidence of inputs claim, because assuming they attach the invoices, I could have known the components of what they are going to submit. And so I wouldn't know. It's what the company gives that you work on, you know. I ask you to provide a documentary evidence of impute claim. An impute, it should be direct to the direct production of the good, which is glass, you know.
Thank you.
And which nylon and carton tray are not part of, or pallets. Those are storage and transportation stuff. They shouldn't form part of impure clay. They are not allowable, which I disallowed. That's the
Thank you.
bone of contention. Yeah.
Is it, the summary of your answer is that you requested for documentary evidence of impute evil and they were not given to you? Is that the summary? No, I want to declare, it can't be you.
Some were provided, and the one that are not relevant for the cost of producing bottle were disallowed. Like carton tray, shrink nylon, and pallets with cable. They are not part of direct production of that bottle. They are for storage and transportation.
Thank you very much. Answer, are you done? Do you have any other question?
Yeah, because so witness does not, the witness is, I don't know whether playing the role of the counsel. But there are questions, these are facts and evidence. And it's a document that came from the witness. So I would expect that.
How many more minutes do you take your question?
Sir, I think I'll take just a few more minutes, sir. I just want to
Have you is
so this will take no more than 5 minutes.
not for the fact.
Yes, sir.
Please, I will speak to both counsel and witness. There will be time for arguments, and that is when you explore all the issues being canvassed. But at this point, I just need let's point the question straight. Let's have the answer straight. When you try to make a question in a way that it's an argument, and we try to answer with arguments, which I will help us. So let the part of this is the question and this is the answer. Let the lawyers eventually will make the arguments and we'll be able to balance. So I will take the answer. I will go through by 5 minutes, but also don't put the question in such a way that it also is arguments.
Noted, as a tribunal police, I take the answer. I take the answer. So I just want to refer against one of the documents. As exhibit. Later dated March 11th.
Please, can you upload this? Exhibit what?
Pizza.
E.
Yes, sir. Later dated March 11th from the yes, sir. Yes, sir. From the respondents consultant. That is a second page of that in the paragraph 2. This
Okay. Exhibit B.
yes, sir. So paragraph 2 of it, page 2 of it, the first paragraph there. Just want to point highlights on this.
Page or paragraph.
Page 2, sir, of that later, paragraph 1, first paragraph. Yes, okay, that's what I'm saying. I will, what's it? 2.0, first paragraph. So the last sentence there on that first paragraph. The applicants committed to providing. So my question on that.
Can you ask your question directly? Yes, as it relates to
The appellant informed you through its letter dated March 11, 2025 of its availability and willingness to provide further information if needed. After providing 2 Excel sheets showing input dates. Is that correct?
Excel sheets are not evidence of invoices. You have to give us sample of invoices for authenticity. You can just draw up an Excel sheet and forward, and it's not taken. So once you want to give an authentic or genuine claim, you attach samples of the invoices. For you drawing up an Excel sheet is just to make a summary of what's the invoices which you claim. So Excel sheets are not enough evidence to tender in court. Rather, the invoice which was used for the impute claim should be tendered.
Thank you. Once you say another question, or your 5 minutes.
I think I'll leave it at that. Any further issue be taken up? Yeah,
Thank you.
yeah, thank you, sir.
No, the examination.
Any prayers?
Well, that's the all for the defense.
Are you sure?
Yes,
The big point.
yes. You only have one witness and she has testified.
What do we do with the witness?
We have found that the witness.
Thank you. The witness is yours.
I think Mrs. Doris, you have been discharged from your testimony.
Thank you.
At this stage, that will be more for you. Let's go. We have like to close our case. We have closed. As a tribunal.
Okay, what we, there we go. How long do you think it will take you to file, serve your final written answers?
Mr. Chairman, I thank you for this wonderful privilege concerning this matter. There is some reason for this, but it's still that it's an issue. The whole issue before the tribunal is question of court. And it will require bringing out the relevant sections of the law, what the law says, the official interpretations, and the.
For how long will it take you?
If we can be given 21 days.
Are you aware that we are actually supposed to deliver judgment with this system of violence?
I am not.
And because of some applications and we did not sit November, December, January. Is it right? We must deliver these documents since we are all closed our cases with various cases. This case has the judgment.
Please, yes, we can tell you. So it's 1 day from now to be around the second window.
That was good. Please, you have to file and serve the 2 weeks. Can you find out the dates? because we're coming back with April for you to adopt your written addresses. So, in 15 days, you're between now and the second day of April. Please, you have to file a SAR.
Hello, we have looked at the direction of tribunal. We don't have option than to us. The directive leading to us. We'll try our best to work within that time frame. But I will also emphasize that speed shouldn't be used as a basis to defeat the whole essence of the scheme. Because even this, Mr. Sherman pointed out, it was not orchestrated by the rest. How can we come to that? We need time to work.
Therefore, you ask for 21 days, 15 days.
We accept. But what I'm trying to say, we should also take note of the different holidays and popular them within this period. Because it might impact on our in the office, we don't work that well. And in general business.
How many days do you think you need to reply?
So, Mr. Chairman, honorable members, I think also accept the good 2 to 3 weeks. No more.
This is 2 to 3 weeks of finance with talking with.
Because we don't have the right to reply, sir.
So if you have a right of reply, you can deliver the date.
Yes.
Please. You have 10 days from the date you start to reply. And we expect that you will start second, according by the 13th of April. But because there may be 1 or 2 days of 12 days. Because then there will be Easter break, which is 2 days. So we expect that you have the 14th, to the 14th day of April. That's actually fast to get to.
As tribunal places, sir.
Therefore, when you receive their reply, how many days do you think you need to reply points of law, if need be?
Well, final working days.
Thank you. I'll give you 5 days, not 5 days.
5 working days, but like, they know us, we're not deliver. If you give us 5 days when we're not in the office, or when there are public holidays, how does it work in our favor? It will not work in our favor. So let's be given 5 working days so that we will not have any in the future. And I come back here and start with this.
Okay, that brings us to 20th. You will still keep it in 5.
As a journal,
So this matter. Accordingly, this matter is adjourned to the 22nd day of April 2026 for adoption.
as a journal,
We're most grateful, sir.
And we ask that if you kindly send us soft copies of these processes to J Flash. Okay. As your final place. You happy about you, don't know this, it's sort of your decisions.
So that will be, we can compare that, but just to make a report, because we are operating from outside jurisdiction, can we send out the email that? That was fiscal flash entail us travel many times.
Okay, let us see the next agenda, why we are not,
I just trying to.
start talking about all the cases, not just externality. Businesses.
Let's try to.
That's what to do. Thank you.
Tribunal.
I think we defend the one of 22nd. They have adjourned. You hear we say like the blue. Now you go defend that one 22nd. That after Easter now.
I will leave the
I didn't.
People will say I've told them I've done this. She is just a problem. It takes to do the work by yourself. From A to Z. So the whole thing is running. If you like the question, all right, so the night. Well, I'm seeing for the first time. Yes, sir. Yes, yeah. I agree. Already discussed. You put